Communicated via email. Okay. Okay, I'm going to go ahead and start now.
The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. This is Maria Maisto. Welcome to our New Faculty Majority Foundation, and Ohio Part-Time Faculty Association webinar on applying for unemployment compensation in Ohio. I'm pleased that everyone was able to join us. Just a few administrative details at first. You should see a control panel on the right side of your screen. If you don't see it, look for a tiny little orange button with an arrow and click on that, and that will open it up. On that control panel, you have the a little function that allows you to ask questions. So I ask you to feel free to use that to ask any questions either about how the webinar is functioning, or once we get into substance about how anything that we're talking about in particular. I'm really pleased to be here with Nancy Grimm, who is an attorney here in Kent, Ohio. Oops, we had a little glitch there. Okay, hopefully everyone can see my screen. Can you see my screen? Okay, very good. We have one of our Ohio part-time faculty members here who's helping us with monitoring how we're working here. So I'm going to go ahead and start. Let's see. Okay, a little bit about me. As you may know, I'm the president of New Faculty Majority and the executive director of the NFM Foundation. I'm also an adjunct at Cuyahoga Community College. I work on committees on part-time and adjunct labor at the Modern Language Association and at the Conference on College Composition and Communication. So if you're in those fields, please let me know, because I'd love to talk to you. And then I'm really happy and grateful that Nancy is here with us, and as you can see, she is very experienced and very involved here in Ohio, and she has helped adjuncts out on unemployment compensation. So we're really pleased to have her here with us to help her out. The way we're going to do this is I'll start out talking about the national context of unemployment compensation for adjunct faculty and what NFM is doing specifically on that project, and then we'll go into the details and the specifics of the situation in Ohio. A lot of people often ask why we are focusing on unemployment insurance. What does unemployment insurance have to do with equity for adjuncts? And it's part of a larger strategy. What we're trying to do is establish regular terms of employment. And by applying for unemployment, we make the condition of contingent employment a little more expensive for institutions. So there's an incentive on two levels. One is to give us the financial means to be able to survive and to get more involved in some activism, but also it gives institutions notice that they can't have their cake and eat it too anymore. And hopefully give them a little bit more financial incentive to start addressing issues of equity for adjunct faculty. We have a particular project called the Steve Street National Unemployment Compensation Initiative. It's a project that we started a few years ago, whose direct goals, as I said, are to provide information about how to apply and appeal unemployment decisions. We also, through our site, collect information about the application and the appeal experience. We take that information and we try to uncover patterns of behavior by states, by schools, by contingent faculty. We use that information to help faculty successfully apply and appeal, so we use their experiences to learn how best to apply in the future. And then, most importantly, probably, we use this information to help educate policymakers, state agencies, and the Department of Labor on the need for reform on these issues. We've already had one meeting with the Undersecretary at the Department of Labor And she was very interested in the data that we had gathered that showed some of the experiences that adjunct faculty have had. So we're trying to get the Department of Labor to issue national guidance that states will receive and that adjuncts can use to help in their application process. The indirect goals of the project are to educate faculty about the rights and resources that are available to you, to empower and encourage faculty to advocate for ourselves, build networks in community, educate the public about adjunct issues, and facilitate efforts to address adjunct equity issues at both the state and federal levels. We hope that if we can have some success with unemployment, we can begin to address other issues as well. And if you've been following the news, you know that there is a lot going on around adjunct eligibility for health care under the Affordable Care Act. We have some questions about legal status, employment status. So we're using this also as a learning experience to figure out some national strategies, state and national strategies on other issues. I just wanted to say a few words about Steve Street, for whom the initiative is named. Steve was one of our colleagues. He's an adjunct in New York who taught for many, many years. Unfortunately, he died of cancer last year. But this was a pet project of his. He joked that our slogan for the unemployment initiative should be "Get up, stand up, file for your rights." He coined that one. I'd like to direct you to an essay that he wrote about his own experience applying for unemployment, because it gives some really good advice about strategy. And although it was specific to New York, it's very helpful, I think, for people all around the country. Our initiative involves several steps. The first one is to decide whether you are eligible for unemployment. If you do not have a continuing contract, then you are most likely eligible. Now, if you have other work, that might factor into it. So there is some individual analysis you have to do. But for the most part, if you do not have a continuing contract, you should look into whether or not you are eligible for unemployment. It's very important to apply. A lot of people don't apply because they think they're not eligible. So once you've determined that you're eligible, or even if you have a question, go ahead and apply, because if you're not eligible, you'll be told. One thing that's really important to try to do is to apply collectively with colleagues. What Joe Barry, who's a national activist who has done a lot of work on unemployment, calls holding an unemployment filing party, where you all get together, you can help each other with the application. There's safety in numbers, and there is some basis, perhaps, for protected concerted action in case you're afraid of retaliation. And we'll ask Nancy a little bit more about that a little bit later. Not most people, but a lot of people successfully apply. I've successfully applied and had unemployment insurance, which was very, very helpful during a difficult period in my life. So if you are successful, collect your unemployment. If you're not successful, start the appeal process. And we are here to help you with that appeal process with various resources. But whether you collect, whether you appeal, we ask that you report to us what your experience is, because, again, gathering statistics both on being granted unemployment insurance and on being denied is helpful for us as we do our national advocacy work, because it's important information that we can give policymakers. This is what our form looks like on the website. If you scroll further down, there's a place where there's a big open space where you can provide the narrative of your experience. And then we ask that people join with us in advocating nationally and on the statewide level on this issue. We need to start educating state agencies and legislators about the way that reasonable assurance on unemployment has been a source of real abuse of contingent faculty, as institutions have tried to really have their cake and eat it too. On our website, we really urge you to read Joe Barry's pamphlet on unemployment compensation, on access to unemployment insurance benefits. It's a national, it has a national scope, but there is some information that's specific to states. And Joe is often available for consultation if you're interested. And then a brief word about some general NFM advocacy efforts on this issue. One of our board members is on the National Education Association Contingent Faculty Caucus, and last year she was able to get a resolution passed. It's called a new business item in the NEA that requires the NEA to help us lobby the Department of Labor to get a clarification letter out to states about contingent faculty members' lack of reasonable assurance of continued employment. In the Modern Language Association, we have similarly passed a motion that actually requires the MLA also to support us in this effort. So if you're a member of a disciplinary organization, we hope that you will get involved on that level as well. Okay, we're going to turn now to the specific process in Ohio. So I'm going to turn it over to Nancy Grimm. Again, I'll ask that if you have questions, you use the control panel to the right of your screen to type in your questions. We'll have them queued up, and we'll be able to answer them, address them during the question and answer period at the end of the presentation. So I'm going to turn it over to Nancy.
Okay. So the first screen here is the screen that you see when you apply online in Ohio. I've never used this screen myself. But I think there are basically two ways to apply these days. Back in ancient times, people used to go to an unemployment office and walk in and stand in line and talk to a person to apply for unemployment benefits. Those times are long gone. You can apply on computer or by telephone. And I assume that everybody in this group is obviously a computer user, and you should use the online application method. And then you receive emails with the follow-up documentation. So the first step is use this screen and follow the instructions. Now, when you do your application, the first step, there may be some follow-ups with some requests for additional information. Follow your email. Whatever information you get, read it carefully and respond. If the unemployment office is asking for information, respond with that specific information. I caution you not to add new issues, but pay attention to the questions that you get. If you get a message saying there is an issue about something, then respond carefully to those questions. The issue we're talking about today is reasonable assurance of continuing employment. There could be other issues that come up in your case. Don't assume that will be the only issue. If the employer is raising some issue about just cause that you were terminated for some reason other than it's the end of the term, then you better answer those questions. On the other hand, don't add questions. Oh, they didn't like me because I yelled at the they said I yelled at the students too much, and that's not true. Don't bring that up if it's not brought up to you. Okay, so the additional application results in a determination. That's what I call step 2, a determination by the department. In Ohio, it's the Ohio Department of Job and Family Services. When you get that determination, if it says you're going to get unemployment benefits, good, start collecting. If it says you're not, read it carefully. It will say what you do if you disagree with that determination, and do it. Basically, what you're doing is requesting a redetermination. They may use the word appeal, and that's something that you do in writing, typically using your computer, but you can add additional information that you send by mail or by email. We'll talk more in a moment about what kind of information you want to be sure to send. But now we'll just go on through the steps. When you get your redetermination, again, it might say you get benefits. Good, start collecting. If it says you don't, then follow the instructions for the next step. The next step is an appeal. which results in a hearing. That hearing will be by telephone unless you specifically ask for it to be in person. It will be a hearing with a hearing officer of the Ohio Department of Job and Family Services. Let's go to the next screen. Okay, so that's, I wasn't sure if we had anything more about the hearing process, but basically at that hearing, it's if you've ever been in any kind of court proceeding, or you've all watched those wonderfully efficient court proceedings on TV, everything's solved in an hour. Guess what? In unemployment, it is all solved in an hour. Those hearings are always scheduled for 55 minutes. That doesn't mean you have to get it done in 55 minutes. If you don't, they'll schedule it for another 55-minute session at some other time. So if you decide you want an in-person hearing, you may have to drive 2 hours to get to one of the few places where they do in-person hearings. I personally prefer to do a hearing in person, but I usually don't because of the cost and inconvenience of going there. I just rather look people in the eye. But if we don't finish in 55 minutes at the Richmond, Ohio hearing site, it's going to be rescheduled, just like if we don't finish in 55 minutes by telephone. So that's something to keep in mind. The hearings are conducted by a hearing officer. You can have witnesses. You will be a witness, and the hearing officer will ask the questions. This screen also shows you some guides that can help you understand the process. So the next few screens, we're going to talk about what kind of information can be helpful in getting a determination that you have reasonable assurance for employment.
Or that you don't have it.
Or that you don't have. You want to argue that you did not have reasonable assurance of continued employment. And as we mentioned before, pay attention as to whether there are other issues in your case. So when you submit information, first of all, at your first application, keep it simple. You're submitting this because your term has ended. You were hired for the last term, the last quarter, or the last semester, and that time has ended, and you don't have reasonable assurance of further employment. And that may be all you say in your initial application because you just have a teeny tiny block on the computer. You may very well get a request for further information because the reasonable assurance issue automatically arises for employment at educational institutions under specific parts of the Ohio statute, specific rules, and that's probably the case in every state because it comes down from some decisions at the U.S. Department of Labor. So there's some specific kinds of information that you can provide that will help show that you have reasonable assurance. You can state your contract ended and you have not been promised any work for the next term. If you had a written contract, you may or may not have had a written contract. If you have a written contract that says your contract ends on such and such a date, you can state that. You can provide a copy. You state that you do not have a contract for the next term. If you didn't have a written contract, then I think it's a good idea to say that. I was hired for the fall semester, which ended on December 10th. I have not been promised any work for the next term. Okay, let's go to the next screen here. There may be some other variations. It may be that they've talked to you, whoever it is who does the scheduling has talked to you about teaching classes. You may think of it in terms of, I've been offered a class. I'd be careful about using that language because that suggests that you have an assurance that you will have a class. When lawyers talk about contracts, they talk about an offer and an acceptance. So if you said, I was offered to teach the introduction to sociology class in January and I accepted that offer, then a lawyer will say, well, you've got a contract. When you're not thinking you have a contract because what you're thinking is, I'm willing to teach that class, but I don't know if that class is really going to be available for me. So that's what you need to say. They've suggested to me that I might teach 1 or 2 classes or 4 or 5 classes, whatever they've said to you, but I don't know if those classes are going to be available, or better yet, anything specific you can say about that, such as, I've taught classes for the last 4 out of 6 semesters, but 2 of the semesters they didn't give me any classes. I was offered classes for the last 6 semesters, but each semester one of those classes was canceled. Each semester I didn't know until 2 days into the semester whether or not I was going to teach a class. Your employer may very well have specific rules about the status of an adjunct faculty member, or or whatever term they use, part-time faculty member. Look for that rule. If you're working for a public institution in the state of Ohio, its rules are all in the administrative code. Currently, it's my understanding that those rules for each institution are not available on the sort of general State of Ohio website for the administrative code, but they will be available through your institution's website. Look for it. There's a very good chance that there's a specific rule, and it probably says something that means just because you have a contract this term doesn't mean you're going to have a contract next term. The universities develop those rules because of other concerns than this reasonable assurance rule. It's because they don't want you coming back and argue that they have to hire you next semester. But use that rule for your benefit. You find that rule, you give a copy of it to the Ohio Department of Job and Family Services. There may well be, let's go ahead and move to the next line, but there may well be similar rules for private institutions, so take a look at your own university or college's handbook of rules and look for that rule that says if you're part-time temporary faculty, you have no promise that you'll be teaching ever again in the future. It's very likely, go to the next point here, that your employer has sent something to the Ohio Department of Family Services telling them that you have a reasonable assurance of continued employment, and they didn't tell you that. Okay, so you want to be, you may or may not know what they have said to you, depending on what stage of the process you're at. You may not know what your employer has told the Department of Job and Family Services. If the department says, we want to know whether or not you have a reasonable assurance of continued employment, one thing you might want to say is, they didn't tell me that. If they told you something specific, tell them what you said. You know, they told me I might be able to teach a Spanish class, but they won't know until January 10th how many students will be, whether there will be enough students available. Be sure that the department knows that. You may have gotten a letter in the past that said, we're not promising you anything in the future. If you have that, tell the Ohio Department of Job and Family Services what that is. You may have an issue that you've been teaching 4 classes every semester, and now you're concerned that, you know, maybe they've said, we can't offer you more than 1 class next semester. If you're driving from Akron to Ashtabula to teach that class, and you really feel that, you know, I can go if I have 3 classes a day or if I have 4 classes a day, but I can't afford the drive to Ashtabula if they only give me 1 class, then that's a good thing to say. Okay, it's a slightly different argument, but it's an argument that might work. It's very particular to your circumstance, and the more it is that, you know, let them know. Your hearing officer may be in Cincinnati and may have no idea how far it is from Akron to Ashtabula, or particularly if you live in Sebring or someplace smaller than Akron. So let them know. That's, you know, a 2.5-hour drive for me. I can't afford to do that for a 1-hour class. And give them the hardship information, and that's another legitimate issue.
And this could be really important now that schools are cutting class assignments to avoid responsibility under the Affordable Care Act. So is that something that they should, if they've gotten memos that say we're cutting classes, can that be added in for the purpose of this kind of information?
Right. Anything, whether or not that particular reason for cutting classes affects you, the fact that, in other words, maybe they're saying we're cutting classes, they may not say because of health care, but maybe they do. And maybe you say, well, it so happens that my spouse has health care and I'm not worried about that. You're still worried about whether or not you're going to teach that class. Mm-hmm. So present that information to the department. Okay. Now, one thing that I think I forgot to put in our outline here, but is important, when you get to the appeal stage, the one that I call the appeal, and they may or may not use that word, but the one that leads to a hearing, that is the first point where you can actually, you can get a little more information, and you should do it. You will get a notice of actually several pages. Read the whole darn thing. Mm-hmm. Fortunately, we're a group of reading people here. And so one of the most important things to do is request a copy of the record. You can do that. It's not a cost. You know, we used to have to pay $5, which was the best deal around, I can tell you, for getting paper copies. Mm-hmm. But now with PDFs, they'll email it to you. Up to that point, you are only guessing at what your employer has told the department. At the point of going to hearing, you can get a copy of that record, and then you can find out what the department, what your employer has actually said. You may have some surprises there. Get that record and find out what it says. Okay, and now we have some suggestions about following the appeal. One, and Paula added this, who's been through this. Read the notice very carefully. You may be under stress. Have a trusted friend read it to make sure you're not missing anything and that you understand it. Everyone taking part in this webinar is literate, but that doesn't mean you're paying close attention to some notice that says you're not getting unemployment for the entire period from May to mid-August. So have someone else look at it. There may be some issues there that you don't pick up on. It may not be written in language that you're used to using. On the one hand, the unemployment office does make some effort to be understood, but they're not the best. They're better than a lot of legal documents I read, but have someone else read it and make sure you understand the notices, the issues, and also make you understand what you can do. Okay? I mentioned the opportunity to get documents. Take a look at that. See what you do to get that. It's very simple to do, but you need to notice that those instructions are there and follow them, and you'll get your PDF file pretty quickly with the entire record up to that point. Another point that will be in your notice is that you can subpoena witnesses and documents. On the one hand, I actually think that there's not a lot of need for witnesses in these kinds of cases. It's not like a just cause case where somebody's claiming they saw you do something and you want to bring in someone else to say, I saw what happened, it wasn't that. I don't recommend that you subpoena someone from your employer unless you know exactly what they're going to say. If you have a witness, it may be a friendly witness, and then you don't need to use a subpoena. You may have a colleague who can say, this is what happened to me. This may be your first semester teaching at this institution, but you may have someone else who can say, you know, I've been teaching there for 4 years, and here's what's happened a lot of the times. And so a witness who can say, you can't count on an offer to teach, that might be a helpful thing for you to have. So you don't need to use the subpoena process with a friendly witness if they'll come and testify for you. And by come, all they have to do is get on the phone at the time of the hearing. They can come sit with you by the same phone, or they can be called in. Again, for documents, if you know of some document that the institution has that you can't get access to, that's when you subpoena a document. If you have the document, you just submit it, okay, and follow. There are other instructions about how you submit documents in advance for exhibits. Follow those instructions and do it, okay? When you get to the hearing, and by get, again, I'm talking you might be going to a place or you might be on the telephone and get called in. You will be questioned. You will have the opportunity to question witnesses. The structure of these hearings is that they don't expect people to have an attorney or a representative. The hearing officer will start off, will explain the process, and we'll start the questioning, and we'll ask a series of questions based on the issues in the case. As an attorney, I have actually done hearings where I asked hardly any questions at all because the hearing officer asked what I thought were all the right questions. And that's lovely when that happens. Okay. But if they don't, then you have the opportunity to ask questions. You may be the principal witness on your side, okay? And so you basically, can ask yourself a question or just say, here's some additional information I want to point out if the hearing officer didn't ask you the question. You may bring other witnesses and you can ask them questions. You can expect that someone will be there from the university. I will also tell you that if they don't show, they don't have to. Okay, if it's your appeal, don't think that you don't have to, that you shouldn't say anything if the university didn't show up. Particularly if you're appealing a case against you, you've still got to make your case. You don't win because they didn't show up. So you still put in your information about why you did not have reasonable assurance of continued employment. Now, maybe by the time you get to this hearing that you now know, like here it is the next semester and you're not working. It may be that now here it is the next semester and as it turns out you are working. And then you're going to have to explain, at what point, you were unsure until such and such a point and here's why. So be ready for that. And, that's the hearing process. At the end, you won't get a decision at the end. The hearing officer will say, I'll let you know later. Okay. Do you want to explain what this screen is, Mike?
I'm going to tell you about a case that was brought by a colleague of ours at the University of Akron. He worked for two institutions, the University of Akron and Walsh University, and he applied for unemployment at both schools, and he was initially denied at both schools, and so he decided to appeal. So when he appealed, and this is important to know, he decided only to appeal the University of Akron's decision. He didn't appeal Walsh University's decision, or maybe it was Mount Union, I can't remember. But and that turned out to be key in the end in the decision. What ended up happening, the final decision was that the hearing officer agreed with him that he did not have a contract or a reasonable assurance of employment with the University of Akron. So if that had been the only institution that he had cited, he would have received unemployment. What ended up happening, though, was because he did not appeal the decision of the other institution, he ended up not getting any of the unemployment. So the lesson there is that if you're going to appeal, if you're going to apply an appeal for all of the institutions that you are working at. We like to include this because Brandon wrote a really good appeal. He also was able to get a friendly witness. The head of the program supported him. That doesn't always happen, and at NFM we're trying to educate department chairs and program heads to help them understand that they need to support adjunct faculty in this effort. If they intimidate you, that's also important information for us to have, because the Department of Labor is not happy about situations where people are feeling like they're not even able to apply because they're afraid that there'll be retaliation from their supervisors. So that's important information to have if you even feel like you can't apply because you're afraid that it'll mean you won't get another assignment. But Brandon was lucky because he had a very good program head, and he wrote a very good appeal. And he also got a very good hearing officer who examined all of the information very, very carefully and even went to the Webster's Dictionary definition of assurance. And he was also lucky because the University of Akron has a rule that specifically states that part-time faculty have no expectancy whatsoever of continued employment, and Brandon was smart enough to put that into the record. So the only logical conclusion that any reasonable person could come to was that he did not have reasonable assurance. And so it was kind of a Pyrrhic victory in that he won that part of the appeal, but because he didn't apply at the other institution, he did not get unemployment insurance. So that's important to know. We're going to ask you to submit any questions you might have at this point. And Paula, are you seeing some of the questions? Okay. Here we go. So it says, one question is, I'm sorry, it's hard to read them. Does it matter if your spouse has an income or not?
I can answer that question. No, it doesn't. Unemployment benefits is all about you.
So you could be married to a millionaire.
Right.
And you could still be entitled to unemployment. If I receive a written notice specifically stating that I have reasonable assurance, is there any way to argue that I do not? I suspected that this question would come up because we have heard that Stark State is issuing letters telling adjuncts that they have reasonable assurance. So that's of particular concern. So how do we address that, Nancy?
Yes, there is a way. And in fact, I would say that I think that every one of you should assume that, well, unless you know that your institution supports the adjuncts getting unemployment benefits, you should assume that whether or not you got such a letter is going to the Department of Job and Family Services, because the regulations actually say that that's the thing that the institution needs to do if they want the conclusion to be that you have no reasonable assurance. So if the letter says you have reasonable assurance of continued employment and you believe the facts are otherwise, you don't feel like you have reasonable assurance of continued employment, then you put those facts out there, okay? This is what they said in the letter, but they told me such and such. This is what they said in the letter, but this is what happens every term. This is what I have seen happen. I've looked at the course schedule for the last 3 semesters or 6 semesters, and this many classes were canceled. Whatever you can put out there. Just because they say it, it's not true, but if that's the whole record, the hearing officer is probably going to assume it is true.
Okay. Another question is, if you are receiving STRS retirement, will this affect the chance of receiving unemployment?
There may, probably, because you are receiving other income, okay? This is another factor. On the one, we had the question earlier, your spouse's income, no, that's not an issue. But you could be found eligible for unemployment benefits, but then there's a set-off for other income. So if you, and if you're getting STRS employment benefits, pension benefits, I believe, I'm not actually certain of this, but I believe that the pension benefits count as a set-off. That you might want to check, because I hadn't thought about this question specifically, but I'm pretty sure that that would be a set-off. Certainly, if you get, if you get some work, then there's a direct set-off up to the maximum unemployment benefit, which is, shall we say, not huge. So that could be a factor. If you know you're going to have some other work other than your university work, that's there for you, whether or not you get this teaching job, that may be a factor not to bother applying, because if you accept it and then you don't follow up with it, that may affect your. It may not be worth the fight. Whatever.
Right.
Yeah.
Another question. Someone says that they are currently on unemployment insurance for prior employment. My final tier will end in 6 weeks, claiming wages at the University of Akron that this is my only job. Would this be a new claim?
I believe this would be a new claim.
Okay. That's good to know.
The other thing is, that's one of those questions that if you do it as a new claim, the staff will figure it out. I used to tell people, why don't you just call them up and ask? But I think what they'll say is, just apply. We don't have time to answer your question. Yeah. So just apply.
Yeah. We have had some people ask about the requirement that you demonstrate that you're applying for other jobs while you are putting in your applications. That's important that you demonstrate that, right? That is very important. Follow whatever the rules are about your weekly reporting. And continue that even if you're losing, okay? It's a shallow victory, very hollow victory. If you go all the way through the appeal period, you lose at every step, and then you win, and they say you're entitled to benefits. If you have not done your weekly reporting of your efforts to find a job, then what you're entitled to is exactly your first week of unemployment. Wow. And what constitutes applying for jobs? Can you just demonstrate that you have been looking? Do you have to actually have submitted applications for other jobs? Do you have to have had interviews, that kind of thing? What kind of contact do you have to demonstrate that you've shown that what you need to do is you need to answer the exact question that they asked you, which I believe is contacting employers. Okay, so you don't. And these days, contacts happens in so many different ways. In any of those ways, if people who walk up the street and walk in every door and say, "Do you have any jobs?" That's contact. People who are going online and responding to, on monster.com or going to the Job and Family Services office and using that computer because they don't have a computer. Again, that's not the folks here in this webinar, but it's contact. It's contact. Yeah. And then it's telling. As I mentioned during my presentation, NFM is involved in trying to get the Department of Labor to issue what's called a UIPL, or a guidance letter, that specifically explains how contingent faculty do not have reasonable assurance, and provides example cases that hearing officers can use. What we're hoping is that if that gets issued, once that gets issued, that would be one of the documents that folks could take into the hearing. Do you think that would be helpful? Is it something that they should use from the very beginning of the process, or is it something they should bring in strategically at some point during the appeal? What would be the best use of that kind of a guidance letter? This would be a guidance that says these examples help show. It might be something to bring to the hearing. It would not hurt to put it in at the initial step when you, actually I would say you might as well get it in the record early, which is not going to be at your first application because you've got a, 140 character little box to fill. But the first time, if you get asked questions before the first determination, then you could submit that along with examples. Here's the guidance, and I am submitting the following examples from that guidance. That might happen at that step. It might happen at a redetermination step. But it's good to get it in the record, so it's there to see early on. Okay. We have another question. What if you have temporary employment at a different institution, June, July, artist in residence? Is unemployment eligibility still possible from the university? You're looking at a question of whether or not you have partial unemployment. And so it depends on to what extent that other employment is. But basically, if
I mean, one easy measure is if that other employment is bringing you wages that are greater than the maximum unemployment benefit, then don't bother.
Okay. Another question that we've often gotten is, what do we do if we're told that, if someone is told that they have to repay, if the determination, if the appeal fails and they have to repay the benefits? What kind of recourse? Is there any kind of recourse at all?
Well, there are some strategies.
Okay.
We've actually, my colleagues and I have had a lot of discussion about this. We used to feel pretty comfortable telling people, don't worry about it, never saw them collect. I'm not so comfortable about that anymore. In the last 8 to 10 years, I think the Department of Job and Family Service has gotten more aggressive about sending dunning letters and threatening to, I'm not aware that they've actually ever sued anybody, but they might. I mean, they have the legal right. The statute says that that you have to pay it back.
If you're found to not to have qualified.
If you're found not to have qualified, and it is, yeah, it isn't just about fraud. Okay, the statute is a little bit stronger language if you're found to have defrauded. But basically, you could have been, and I've met people for whom the situation, you could have been winning at every stage, and then it gets turned around at the appeal period, or even at the court level, and then you know, by that time you've got a whole, you know, period, an extended period of unemployment benefits that you've received, and they say pay it back. And in my view, I have known attorneys who said to people, well, you know, just don't spend your unemployment benefits, just put it in the bank. I don't tell people that. The purpose of unemployment benefits is to, you know, get you something to eat every week, and I encourage you to get yourself something to eat every week. There are some limits. One limit in the law is that there's a 3-year limitation period on collection by the Department of Job and Family Services. My recommendation is, if they get particularly aggressive, is that you contact, you want to make a deal before it goes to court, okay? And so you contact whatever contact comes to you you've been getting several letters saying, send us that $3,000 back, and you're thinking, you know, I just bought bread, that's it's gone. Contact them and try to make a deal that's making some kind of monthly payment of as low an amount as they will accept. And I have not tested this, but other attorneys who've kind of worked through this are pretty confident that when 3 years are up, if you've made this deal outside the court system, that's it, okay?
So even if you haven't repaid the whole amount?
If you haven't repaid the whole amount. So, you know, make a deal. And I always say that, I mean, whenever you're settling something, never promise more than you can do.
Right.
But if what you can do is $10 or $25 or $50, or, you know, make a deal, keep to it, and it should stop after. And after 3 years, they're not going to suggest you stop, but probably after 3 years, you're safe. Now, I think the other part on that collection issue is that it could come up if you need to seek unemployment in the future. Okay, and that's the easy one for them to do. And I've always felt that was there, is if you got your $3,000 and then you become unemployed sometime in the future, you go through, you make your application, and it's a finding that you're entitled to unemployment benefits, and you get a notice saying, fine, you're entitled to unemployment benefits, and we're going to credit you for benefits, and once you've been credited for $3,000 worth, then you'll start receiving the money. So that's always going to be hanging over there if you're one of those unfortunate people who, at first fortunate, but then unfortunate, who got benefits for a period and then got it turned around. Okay. There is that danger.
Okay. I don't know what the statistics are about the number of people who receive benefits, and then the determination is turned around, and then they're required to repay. I know that that's a reason that a lot of people are afraid to apply. So it's also one of the things that we're probably going to raise with the Department of Labor. I don't know, or with the Ohio Department of Job and Family Services. And it, I think, is an argument for why there needs to be clarification on this issue.
Yeah.
But I hope that people won't let that deter them from applying, because it can end up sort of working out to be sort of almost a loan. Kind of in practice it functions that way. Yeah. David Wilder, who's here, who's one of the organizing committee members of the Ohio Part-Time Faculty Ohio Part-Time Faculty Association, also has a question.
I just wanted a clarification on the last point, because now I'm worried. I received unemployment benefits, and I thought that getting the positive determination and receiving the benefit, that was the end of the appeal process.
Oh, the school did not appeal. If the institution did not appeal his determination, then it's done, right? If the appeal period is over, they've lost their chance.
Once you've, each decision, you and the institution get a copy of the decision, and that decision says what the deadline is for a further appeal. And the notices I have seen will say not only 3 weeks, but they will say, and we calculate it to be March 24th. And so once that, if it's, once March 24th has passed, that's the end for the appeal. The only caution I would give is you don't know on March 24th whether or not the institution has appealed, because they don't have to tell you, they just have to tell the Department of Job and Family Services. So it can happen that sometime later than that you find out they've appealed. But once the appeal, I don't know that those delays are happening so much now that everything is on computer. In the past I used to see, like, weeks later someone would get a notice like, how could they appeal? It's way too late. And it would be, it turned out that they did it timely. It just took them that long to tell you. But once the appeal time is passed and no appeal has been made, no appeal can be made. They can't come back 6 months later and say, oh, now we want to take this to the next level.
Right, because it works that way for you too. If you miss out on your window to appeal, but it works on the institution as well. Why is it that they don't have to let you know that they're appealing? Well,
in a way, it's a simplified rule of appeal. When in all of these proceedings, except possibly at the actual hearing level, all of your communications are with the Department of Job and Family Services. You're never required at any level. You don't make your application to the employer. You don't submit your further information to the employer. It's actually why you don't really know what the employer is saying, because both of you only communicate with the department. So you find out that there's an issue, you find out that there's an appeal at each step, because you get a notice from the department saying that there's been an issue made.
So if the institution is going to appeal, then the department should be letting you know in a fairly timely manner then. So that
the Department of Job and Family Services.
Yes.
Yeah.
Okay. Very good. I don't see any more questions, so if you have a question, we have just a few minutes left. I'm going to go ahead and wrap up. So if you have a burning question, please let us know. Oh, there might be one last question. Okay, someone says, I've been denied every time, even though I have a letter stating that I will not be employed. I'm told that I am not monetarily eligible. What does that mean?
Okay. There are certain standards for what it takes to be eligible for unemployment. And you can take a look at these by checking the website, and actually I think that guide for workers that was on an earlier page we have will have those factors in them. But one of the factors is how many previous weeks of employment you have, and also how much, a minimum amount of money that you are earning in each of those weeks. So it's possible that if your past several weeks of employment or many, many weeks of employment have been, for example, just teaching one class, it may be that the amount that you made was not enough to be eligible, aside from other issues.
Yeah. Yeah, I'm only teaching one class, and that's why I haven't been applying, even though my class was canceled last spring, but I didn't apply because I knew I wasn't going to be monetarily eligible. I hope that answers that question. To wrap up, we want to encourage you to get involved with the Ohio Part-Time Faculty Association and with New Faculty Majority, because as I mentioned, we are trying to advocate on many levels. Here in Ohio, in case you don't know, there has been a bill introduced, a House bill and the corresponding Senate bill, to amend the Ohio Code to allow part-time faculty and graduate students to unionize, although technically what it really means is that they'll be able to be defined as public employees for the purpose of collective bargaining is technically the language. So technically we do have the right to unionize and to bargain collectively, but we just cannot compel our employers to bargain collectively with us. But this amendment would change that and would allow us to compel our employers to bargain collectively with us. So please visit our website and keep up to date on that particular issue. David, do you want to say anything about some of our activities that we're going to be, we've been talking a little bit about kind of doing a tour of the state, going out and meeting people at campuses around the state. We have a listserv on the Ohio Part-Time Faculty Association website. We encourage you to check it out and to subscribe. There's been some good conversation, good ideas. There are conferences coming up that people can get involved in, including one in Pittsburgh with colleagues in Pittsburgh who are organizing. So please check those out. We have one other question coming in under the wire. If I get almost all of my income from one institution and teach very part-time at another school, total income from this institution is less than $2,000, do I need to apply for unemployment from both?
I would say yes. That was exactly the problem, as I understand it, that Mr. Sloan had.
Mm-hmm.
And yes, apply for both. It will be, it's not that your poor small institution is going to end up paying all your unemployment benefits, but your best tactic is you better make the application for both. Otherwise, you could lose out with respect to your major employer.
Is it possible that you could, like if he had applied for unemployment based on both denials, if he had won one and lost one, would he have gotten sort of proportional unemployment from one and not from the other? Or,
I'm not sure how that would work. I would think, I would think that would then become a question of partial unemployment.
Okay.
Yeah, because you could have one employer. It's certainly possible that would be a correct answer.
Mm-hmm.
You could have one employer say, "Here's a written contract. I'm promising you a course next semester," and the other one says, "Yeah, you might have a class if we have enough people."
Right. Or you have no expectancy of whatsoever of continued employment. Yeah. So the bottom line then is apply. that if that's the final point, then I hope it's a good one, and I hope that you'll stay connected to the Ohio Part-Time Faculty Association. We are going to have an unemployment filing party in our Akron office, and hopefully we can help others around the state to do the same. Please get in touch with us. And let us know any feedback on this webinar, additional questions you might have. And thank you very much, everyone, for joining with us. And we look forward to meeting you all at some point in time. Thanks very much.